Welcome to the Wise Fiduciary Podcast. I am Isaac Wood, one of your hosts from Fiduciary Wise. Whether you're a thought leader, service provider, CEO, or decision maker, this podcast is for you. We break down best practices, the services and solutions available to you, discuss the latest topics, and shake up the industry norms. Join us as we explore, challenge, and navigate the future of fiduciary responsibilities together. I am excited for this very special reaction video. Isaac Wood here, ERISA 402A specialist at Fiduciary Wise. I'm joined by my co-host, Marta Hurst. Hi, Marta.
Hello. Thanks for having me. This sounds like a super fun episode for us.
We are so excited for this episode because we are reacting to our own podcast. And so we are going to be actually listening. We released just recently a very extra special episode focused on the Cunningham versus Cornell University Supreme Court decision and the impacts, ramifications, and such that has on the 401k industry. The episode that we released earlier was our good friend and co-host, Kate McBride, co-host of the Wise Fiduciary Podcast. She had special guest Jim Watkins on, who is an ERISA attorney. And he discussed sort of the effects that this Supreme Court ruling has on the industry. And so what we wanted to do, they are very good at what they do, and they are what we affectionately refer to as fiduciary nerds. And so they very much nerded out on this topic. And so Marta and I just want to pop on here and just kind of have a reaction to some of the elements that they called out on in that podcast and in that episode. And then we want to go a little deeper and just kind of take it to the application of what does that mean on the streets? What does it mean to a plan sponsor? What does it mean to a financial advisor that is working in the 401k industry? Marta, any thoughts on what we're doing here today? We're in movie
I'm so
mode.
excited. I got my popcorn. I got my big Stanley for today. So, I mean, my cup's not quite as cool as yours. But we are excited to kind of break into some of the highlights of this. Although I certainly recommend watching the whole episode. Jim is really brilliant and has a lot of good insights into this. And Kate did a good job of helping facilitate that interview with him. So let's jump in.
Yes. So this should be your second watch. Watch the full episode and then come in and watch this. This is not a Cliff's Notes for you to be able to test out of watching the other video. Watch them both, please. So let's join Kate and Jim and see what it is that they're talking about.
We had never had a case which had thrust the burden of proof on the defendants in an ERISA case. This was the first one, and the court basically told plan sponsors that because PTEs are affirmative defenses, it's your burden to prove that the PTE applies to you.
Let's talk about what a PTE is, Jim, for any plan sponsors or anyone watching that may not know what it is. Can you elaborate a little bit on that?
PTE stands for Prohibited Transaction Exemption. ERISA sets out certain acts that are prohibited, and primarily those acts are acts which would compromise the best interest of the plan participants, or if there's a conflict of interest on the part of a person trying to sell a product or a service to the plan. So if you fall into that area, and anytime you're trying to sell a product, these always come into play. There's the conflict obviously being this person stands to receive compensation. So if you're engaged in a prohibited transaction, you need to find an exemption that will allow you to receive those funds.
Those are all together in ERISA. In other words, when I say together, not on the same page, but there is what happens if you break a rule, and then this is how you fix that. Basically, sort of a, hand in hand. Here's the rule. If you do this, you've broken it. And here on the other side is the remedy for that. These are the things you need to do to not be guilty of it. Is that
Yeah,
an adequate way?
I like your first part better than your last part.
Okay, how would you do it? How would you say it?
I would say, well, let's go back. There are two sections, and this was a critical element in Cunningham. The court pointed out that the prohibited transactions are set out in a separate area of ERISA. So that's 406. 408 sets out the exemptions. And what the court said was because they are set out in two separate sections, they're not the same thing. And therefore, the court said, as a result, if you've engaged in prohibited transactions and you want to try to do the exemptions to protect yourself or clear yourself, get out of jail card, then that's under the law. And this is true of anything. Under the law, if you're going to assert an affirmative defense, that's your burden of proof. And so that's why this was so important. They are now saying it's not the plan participant's responsibility, it's your responsibility. And in most cases, it's hard to meet the conditions that the exemptions set up.
All right, Marta, a lot there, and there's a lot of legalese there in that conversation because ERISA is a legal document, but this idea of prohibited transactions is really at the central point of this Supreme Court case, Cunningham versus Cornell University, right? And so, what is a prohibited transaction in ERISA's mind?
It sounds like paying people out of a plan is a prohibited transaction.
That's wild to me.
Yeah,
That is wild to me. So, like this, any fee on a 401k plan is a prohibited transaction. And so
then you got to find your PTE.
how do you do it?
I'm so glad Kate asked
Yep.
that question. I'm like, I mean, I know the term, like just what we needed in this industry is more acronyms, right? So I feel like I hadn't heard PTE in forever, and now I hear it all the time, PTE, because this case, has it at the top of everybody's
The last couple
mind.
of weeks, it's
all over the place.
yeah. And
right?
so I'm not sure the average plan sponsor on the street, or really the average financial advisor, understands that adding any fee from a service provider to a 401k plan is a prohibited transaction under ERISA. And so what they do then is they give you these exemptions, these PTEs, a prohibited transaction exemption that really says you have to test into the ability to charge a plan. You have to qualify so that there's a reason that you're added, that your fee is deemed acceptable and not prohibited in your ERISA 401k plan. And so that applies to every single service provider, as Jim did a great job mentioning, just by the fact that you're getting compensated for the service you're providing. That's a conflict of interest. And so there's a prohibited transaction exemption that has to be qualified for in order for it to be applied to the plan.
And he told us where to find it. So he told us what sections to go find it in. Now you just got to find the find.
You got to go find it, and then you got to make sure that you qualify for it, right? And so in the courts, when it applies to ERISA, I think this is important because when we talk about courts, we tend to think about the courts for non-ERISA, like your regular, like stole something, killed someone, those type of courts, right? Where we know that a defendant is always innocent until proven guilty, right? That's what we think of with our court system. But in this specific case, in ERISA, right? So you're making, and this term Jim used a lot, is this affirmative defense. So if your defense is, my defense is that I have qualified for this prohibited transaction exemption, that means that the burden of proof is now on you to actually prove that you qualified for it. And so,
pretty fascinating.
You're not. Your defense is not that I didn't have a prohibited transaction. Like you can't say I didn't charge money. Like, and so that's where it takes to this. You're guilty until proven innocent in these courts. Very much so.
Like the only time that you see that in court, right? Otherwise, like
Yeah.
you said, it's innocent until proven guilty. Not anymore. We're doing this shift of proof. You then I, as the plan sponsor, would have to prove that I have this PTE, this prohibitive transaction exemption, in place, and burden of proof is on these employers. So it is a big. These 2 points are a big deal. This
It's a
having the
big deal,
affirmative
and
defense.
it's not new.
It's not new.
Like that's the way it's always been. And so what has changed now is that the courts have said, "Hey, remember, this is the way it's always
That's right.
been." And so what has been happening over the years is that the lower level courts have been receiving lawsuits, and then they would kick it back to the participants that were bringing the lawsuit and say, "Hey, you've got to prove that they didn't do this."
Which, how difficult is that as a plan participant? Because typically, I mean, you might have some fee disclosure information, although we'll talk about maybe in a little bit. A lot of these cases have to do with there were fees charged that weren't disclosed, and so as a participant, how could you possibly prove it? So I think
Right.
this shift is, and Jim mentioned in the episode, it's a long time coming. This is the way that it was intended and the way that it should be. And to see the court say, yep, this is how it's supposed to go, is meaningful for our industry.
So we anticipate, and we've already seen since this court ruling came out just a few weeks ago, we've seen an increase in lawsuits in the 401k space. And we would anticipate that to ratchet up because now the burden of proof is on the defendant, on the plan to prove that they qualified for these prohibited transaction exemptions. So if you're a plan sponsor, if you're a financial advisor, would your plan specifically, if you're an advisor, all of your clients, would they be able to prove that they qualify for a prohibited transaction exemption for every single fee that is being assessed to that plan for every single service provider? Are they capable and able to do that? And so that's the question at the heart of this issue now as we go to apply it to the streets. Can you do that? And if not, how can you do that? And so let's go on to the next session because Kate and Jim continue to kind of unwrap some additional elements of this court case that are important for us to discuss.
What are some of the things that you, doing what you do as an expert witness, as an ERISA expert, as an attorney, what can plan sponsors do to try to have a better plan that won't have this fate of being sued? How do you mitigate that in terms of having a plan?
Well, I think
participants.
I think the first thing is to understand what the laws are. You and I are both fans of the Restatement of Trust Third. And it's amazing to me how many times when I go out to meet a potential client, one of the first questions I ask them is, have you ever read the Restatement? And they give you the deer in the headlights look. And it's like, I kid you up, there it is.
With all the Post-its, and place
with the multicolor stickers.
It's one of those things that
I told you,
Jim
nerds
and Don Jones of our firm, Fiduciary Wise, have talked about for so long, and I'm not a lawyer. I should say that right off the bat, not even close. But this is such a common sense written book that you can look at the relevant areas of this book and really understand, and it's put in very plain language, that if you have a trust or if you are running a plan, that everything you do has to be in the very best interest of the plan participants or that beneficiary of that 401k or trust. That's the end of it. I mean, it's the beginning, middle, and end, really. And if that doesn't happen, then lawsuits like this happen.
Well, and Kate, remember what a lot of the courts have said. The courts have consistently pointed out that ERISA is essentially the codification of the restatement of common law. Yeah. So it goes back to what you just said. If you want to understand ERISA, look to the restatement.
Yeah, I've heard people say that the ERISA is sort of outlines what has to happen, but the restatement of trust tells you how you do that. Because ERISA itself doesn't say how to do it; they just say you have to do it. But the restatement of trust will actually go through and say this is what you do, which is why these books are valuable if you're a serious ERISA person or a plan sponsor, or if you need to know what you need to know.
I just have to say,
I love the
Jim
statement.
said he was surprised
go ahead.
when he would talk to clients and say, have you read the restatement of third? And they gave him the deer in the headlights look. That does not surprise me at all, because I hadn't even heard of the restatement of third until I started working with Fiduciary Wise. And now I got my own book. Does not have as many sticky notes as Kate's. Kudos to Kate. But it doesn't surprise me. I mean, these business owners are running their business. They are not engrossing themselves in law books.
Yeah, I think codification is now one of my new favorite words. Once I heard Jim use it, I don't even know that I know what it means, but I just love it. But he said ERISA is the codification of the common law of trust. The codification. I don't even know how you say it correctly.
Yeah.
But what that means, so the common law of trust existed before ERISA, and I love how Kate summed it up there. That ERISA tells you what to do in the 401k space, but it never really tells you how to go about doing it. The how, and the Supreme Court has in multiple cases stated this, you were to refer back to the Restatement of Trusts, the common law of trusts, to find out how. And they continuously refer plan sponsors back. So that actually makes it even harder for plan sponsors, because not only do you have the 500 pages of ERISA, you now also then, that just tells you what to do, to figure out then how to go do it. You've got this whole other book that Kate has on her shelf, that Don Jones has on his shelf. You've got a copy on your shelf. Mine is in the mail. Like, I don't know that I'll ever read it and memorize it like they do. Like when I say a wise fiduciary is a fiduciary nerd, that is a loving term. And you need a fiduciary nerd to be able to work through all of this and to know how you are meant to do what ERISA tells you to do.
100%.
All right, let's keep going. That codification, restatement, trusts. This is good stuff.
You talked about reading the restatements. What are some of the other things that plan sponsors can do to learn what they need to know, or to shift what they need to know to prudent experts?
Well, I think, in my opinion, the two easiest things to do, even though it's a self-serving statement, is retain the services of a knowledgeable and experienced ERISA attorney. From a practical aspect of administration, I am currently recommending to more and more of my clients to consider a 402 administrator.
Hey, that's us.
There's so much volatility right now in this area. At a minimum, talk to a 402A administrator. Let them explain what services they can provide. Because if you want peace to sleep at night, a 402A assumes all responsibility for the plan's administration. It does not relieve the fiduciary of fiduciary duties, but all they have, if they retain a 402 administrator, they just have to monitor what they do and simply go, okay, why did you do this? And if they can't explain it, then that should put you on notice of a red flag.
That's a great point, Jim Watkins. So if you actually are in need of a 402A, you can go to fiduciarywise.com/scheduling, as we will mention again later, and go ahead and have a conversation with the 402A. But this idea of that there is professional help is another truth bomb that many plan sponsors and financial advisors don't know, right? That ERISA requires this to be done. They require that it is done according to the common law of trusts. But then they say, if you can't do that to the highest standards under ERISA, go get yourself an expert. And
Yeah.
guess what? Those exist.
And if you're watching this podcast, you know one. So I think that this is it's difficult, right? I mean, he just talked about the complications of it. It's a great opportunity to be looking at your plan and explore options for professional help. So let's keep it going.
Sorry, Amanda just came in and stole my popcorn.
Jim, let's go back to Cunningham versus Cornell University and talk about some of the impacts that you're seeing from this ruling from the Supreme Court of the United States, this earth-shaking opinion that came out last week. What are you hearing about from your clients or folks that you're talking with about the impact of this, and what can plan sponsors do to help to protect themselves and their plan participants?
Well, as far as protecting themselves, I know they don't like costs. I think now would be a good time to consider a fiduciary audit. The important thing is every aspect of the plan needs to be reviewed, because what Cunningham said is that if questions arise as to your plan, you're going to have the burden of proof. So what we're seeing and are going to see in Cunningham, I think everybody's predicted we're going to see an increase in litigation against plan sponsors. I think that's true. As an attorney, I think a question is going to be plans that had legal action under ERISA and the courts dismissed their actions because they tried to put the burden of proof on the participants who didn't have the necessary information.
Mm-hmm.
I think attorneys are going to have to go back, or I think they have a legal duty to go back and ask the court that ruled against them and dismissed their case to reconsider their ruling in light of Cunningham. And from talking to a lot of attorneys, they are discussing that as to whether or not the plan wants to do that. And along those same lines, if you're a plan sponsor after Cunningham, and if you do not at least ask the court, given the importance of this ruling, to reconsider, there's a question, or at least in my mind, there's a question as whether the plan participants can claim a breach of fiduciary duty for not pursuing recovery of that possible money. So I think we're going to see the litigation. I think a lot of attorneys are going to have to go back, reconsider what they did. And the other thing is they need to talk to an experienced legal counsel, because this is complicated. I think we're going to see more cases shifting the burden of proof on them. So now's a good time to figure out, okay, if that burden were thrust on us, could we meet that burden? And I'm on record. I don't think they're going to be able to meet that record either with regard to mutual funds and certainly not annuities. So they're leaving themselves exposed to unnecessary liability exposure.
See, we were right.
We were right.
I love this idea from Jim of a fiduciary audit, and that now is the time to make sure that your I's are dotted and your T's are crossed, because the courts have told you that you need to. And as Jim mentioned, we've seen an increase in litigation. And so what does it mean to have a fiduciary audit?
It means you look at and he mentioned looking at every aspect of the plan. So when we talk about being a 402A named fiduciary and we kind of give the breakdown, we've got the legal legal and management, investment oversight, and administration. So all of those areas are under ERISA. We see investments more in lawsuits, obviously, but there are other fees that are charged to the plan, as we know, and we have seen some other lawsuits surrounding excessive fees. So what services are being provided, who is being paid what, how did you make the decisions to choose those service providers that you have? Are they meeting their contractual obligation to the plan? Are they providing the services that you thought that they would be? All of that stuff and the documentation of all of that, not, well, he's my brother-in-law and I like him a whole lot. I know that's a little extreme of a case, but we run into plans that they haven't done any review in a long time. Over time, fees, if you've got an asset-based fee and your plan continues to grow and nobody ever adjusts that, at some point that's going to be out of whack. Who is keeping an eye on things? Who is monitoring this? How are you documenting the process? That's and doing a fiduciary audit. I would not wish any plan sponsor to have to do that on their own. Certainly there are resources and
You
people
can't
to
do it
help
on
do
your own.
those things. Yeah. I
The
mean,
only way that you can do a fiduciary audit on your own is if you were doing all of those things because you knew they existed already. And so what we've already kind of established is your average plan sponsor isn't aware of all of this. And so if you're not even aware of what needs to be done, how can you audit that it's getting done correctly? And so I think of this fiduciary audit, there's two sort of elements of this. One is just the benchmarking of all the fees, right? And this one we're a little more familiar with in the industry. We're used to benchmarking things. And so it's what are the fees that are being paid and how do those compare to the industry and what's available right now, right? But benchmarking goes beyond just the fee that's being paid. ERISA talks about the requirement that the fee be reasonable. It doesn't require that the fee be the cheapest, but it requires that it is reasonable. And how you determine whether it's reasonable is you look at what you're paying, but then you also have to look at what you're getting for it. What is the service that is being provided for that fee? And so when you're talking about a fiduciary audit, that's the second piece of what is it that is being done? What is it that's being done on this plan? So not just I have these 8 service providers and here are the fees and they're within the appropriate guidelines and so we're priced correctly. No, it's what are the fees that are being, what are the services that are being provided, and are those fees reasonable? But then also, as you mentioned, there's 3 buckets of fiduciary responsibility in a 401k plan. There's the legal and management, there's investments, and then there's the administration of the plan, right? You put those 3 together, and that's your 401k plan that your plan sponsor is fiduciarily responsible for oversight on, right? That comes along with over 100 different fiduciary roles, services, and responsibilities, over 60 of which are very meaningful and trackable, right? And so it's like, do you know what those are, and are you able to say that they're being accomplished? Because all of your service providers are appropriately charging the right fee for the services that they're providing, and they're all cheap because they're not providing hardly any services. You're not in compliance because you're not getting done all that needs to be done on the plan. And so when we in an audit benchmarking world, we tend to want to race to cheapest. If you have all the cheapest providers on your plan, they're probably not bringing the highest standard of service to the plan. And so to make sure that you know what the fiduciary roles and responsibilities in a plan are, and then that they are being executed and that they are being executed to the highest standards under ERISA, that's a lot on a plan sponsor. And so
right. And now it's their burden to prove, right? So,
and it's on their burden to prove that that's all happening.
I think when you're looking at this, it's no longer like, okay, well, these guys were pretty good and they're pretty inexpensive and let's just do it. Like when you think of it from a burden of, well, at least when my mind goes to a burden of proof, thought process, it really kind of changes from, okay, this will work, to like, oh, how do I document that I made a good decision, that I was thinking of my plan participants, that we went through a prudent process. So it really, in my mind, shifts the way plan sponsors should think about the decisions that they make for their plan.
And you need a fiduciary nerd. You need a fiduciary nerd to go through that. someone that is, as Kate mentioned, serious about ERISA. You need that person to be able to educate you on this is what needs to be done, and this is the levels at which that needs to be done.
All right, you ready for more popcorn?
Yeah. All right, let's take a look at one last clip here before we wrap up.
How different is this case from so many of the other cases that we've seen in the last, it's something like, is it at least 500 cases since 2016 or so, something like that?
It's a lot.
Yeah.
The late Justice Ginsburg made a comment that the Supreme Court typically does not like to hear ERISA cases. ERISA law is complex, and a lot of people just aren't familiar with investment. So if the issue is compensatory return relative to alleged excessive cost, they're just not prepared to analyze that. So this was an atypical case in that it involved issues of clear wrongdoing. So it was easier for the court to apply here. And to be honest with you, we talked about the restatement earlier. The restatement, there's a section of the restatement, section 100, that says that if the plaintiffs established that a breach occurred, then the burden of proof shifts to the plan sponsor. The problem is we've got too many of the federal courts that have ignored the restatement. So that was a key issue here. We were talking earlier, I think they need to go further, but this was the first instance where, and the court did reference the restatement for saying the burden shifts. I mean, this wasn't a complicated case. Back in the Tibble case, the Supreme Court ruled in fiduciary cases, look to the restatement. And that's exactly what the Supreme Court did in Cunningham. It looked at what I just referenced, Section 100.
So this is where our Restatement of Trusts third comes in, Section 100 of this book. We're not hawking the book. We just use it. So
we don't get any profits from it, but the point here is that it's there. And as soon as the case came down, I had several friends text and email me. The decision of the court shouldn't surprise anybody that's familiar with the restatement. The fact that it was 9-0,
yes,
a unanimous decision, I don't think anyone would have predicted the Supreme Court to have been unanimous.
So yeah, this not only got ruled this way, it was a unanimous. And in today's world, anything that's unanimous anywhere should blow your mind and draw attention to it. And so I love this to kind of wrap us up here. What makes this court case so different? Why are we recording all these podcasts about one court case, Cunningham versus Cornell University? And what Jim said there is it's because the courts have said in the past, they've said over and over and over again, look to the restatement of trust, look to the restatement of trusts. That's how you do this. And Cunningham versus Cornell, they actually did that.
They did it.
They actually went back to the restatement of trust and they did it. And as we mentioned earlier, at the lower court levels, that hadn't been being done for really decades. And so that now that we've seen it actually done, it means that we have, as plan sponsors, we have to start acting this way because we're going to be held accountable.
I absolutely agree. And, Jim mentions many times that ERISA is complex, and it is. And so plan sponsors aren't meant to do this on their own. And there are certainly options, including Fiduciary Wise, to help navigate these plan issues. But I think that this court case was, to your point, we're doing a lot about it. We talk about it a lot within the office. It's important. And I think that we're going to see some more, and plan sponsors need to be ready to realize that they've got the burden to prove what they are doing for the plan is right, that it's in the best interest of the participants, to be monitoring service providers, to be doing all of these things. And I know that plan sponsors they're running their business. Keeping up with the 401k plan is not, probably not something. I mean, I do know plan sponsors we've talked to that say, I lose sleep at night about the 401k because there's just so much of it that I don't understand. And so I appreciate that they might have some concern about it, but I don't think any of them are trying to become ERISA experts overnight following this court case.
Mm-mm.
So, but nonetheless, this is out
You
there,
got to have
and we're
ERISA
definitely
in
going
your
to see some of that.
DNA. You got to have
Yeah.
ERISA in your DNA to be serious about it. And as you can see here at Fiduciary Wise, we got a lot of ERISA DNAers on staff and doing what we do. And as we mentioned, we've done a lot on this specific topic and other topics. So we will actually in the bio of this episode, we will link to the full Kate and Jim episode. But make sure that you go and watch that as well. Make sure you subscribe to the Wise Fiduciary Podcast so you can get all the updates from us. We'll also link the blog posts and other conversations that we have had in the show notes around this specific conversation. You can actually follow us on Spotify, YouTube, LinkedIn for more updates like this and others. Because like you said, once these cases start to hit at a more rapid race, then we're going to be able to see if plan sponsors are able to carry that burden of proof. And as Jim mentioned multiple times, I don't know that plan sponsors are able to carry that burden of proof on their own. So thanks for tuning into the Wise Fiduciary Podcast. It was a joy to have you. We would love to hear your thoughts and answer any questions that you may have. So drop us a comment, send us a message, or you can schedule a meeting with us at fiduciarywise.com/scheduling. Don't forget to join us next time for more insights and discussions. We will see you soon in the next episode. Thanks.
See ya.
This is going to be like a 3-hour long episode.